Let's start with our first topic, legal maxim of the day. What are legal maxims? Legal maxims are those established principles of law, originally quoted in Latin language, which are used as guiding truths by both lawyers and judges internationally, and due to this reason, they are very important. Our first legal maxim is pacta sunt servanda. It's a Latin maxim which means agreements must be kept. It's very important and most popular legal maxim because it is basic principle of contract law, civil law and international law. This principle has been explicitly referred as a universal rule in the preamble of Vienna Convention on the Law of Treaties 1969. Article 26 of the VCLT states that every treaty in force is binding upon the parties to it and must be performed by them in good faith, that is, pacta sunt servanda. Ubi jus ibi, idem remedium. It means where there is a right, there is a remedy. The term just means the legal authority to do or demand something. And the term remedy means the right of action in a court of law. You must have heard the law of torts. The law of torts is said to be a development of this maxim only. In this regard, the leading case is Ashby v. White, 1703. Ashby v. White, or rather, the classic judgment of Lord Chief Justice Holt in that case, is usually cited to exemplify the maxim. In this case, the court observed, when the law clothes a man with a right, he must have means to vindicate and maintain it, and remedy, if he is injured in the exercise and enjoyment of it. And it is a vain thing to imagine a right without a remedy, for want of right and want of remedy are reciprocal. Let's start today with a very important Latin legal maxim. Vigilantibus non dormientibus equita subvenit. This maxim means equity aids the vigilant, not the ones who sleep over their rights. It provides an equitable defense. This maxim can be said to be the basis of Limitations Act 1963. This act holds a very special status because it basically prescribes the different limitations periods, or let's say time limits for different claims, within which an aggrieved person can approach the court for redress or justice. If the suit is filed after the prescribed time or limitation period, the courts will not be of any help. After the limitation period, you cannot enforce your right in the court. To understand this, let's take one example. Suppose you have given some amount as loan to your friend and he is not returning now. Then the limitation period to approach the court as per the Limitations Act is basically 3 years from the date you lend the money. If you do not see your friend within 3 years, then courts will not help you to recover your money. Our example is based on this case, Sri Kalicharan versus Sri Rajiv Kumar Gupta. To read the full case, please go to the link provided below. Alter for a convict, which is basically used as a defendant's plea stating that he has been already tried for and convicted of the same offense. In simple terms, it's called doctrine of double jeopardy. Double jeopardy simply means punishing a person twice for the same offense. Article 20 in the Constitution of India states, no person shall be prosecuted and punished for the same offense more than once. Similarly, Section 300 in the Code of Criminal Procedure 1973 states, person once convicted or acquitted shall not be tried for the same offence. Section 40 in the Indian Evidence Act 1872 in this reference states, previous judgments relevant to bar a second suit or trial. In this reference, we must also know the legal maxim "Oiter foi acquit", which means that a person cannot be tried again for an offence for the reason that he has previously been acquitted in the same offence, and such a plea can be taken or combined with plea of not guilty. These two terms are jointly known as doctrine of "Oiter foi acquit" and "Oiter foi convict". To demonstrate the practical usage of this legal maxim, we have taken the case of 2008 Ahmedabad bombings. Please check the headlines. High Court rejects double jeopardy plea by serial blast accused. The 2008 Ahmedabad bombings were a series of 21 bomb blasts that hit Ahmedabad on 26 July 2008 within a span of 70 minutes. 56 people were killed and over 200 people were injured. These bombings occurred a day after the Bangalore blast and a day before a bomb blast in the Indian state of Jharkhand. In this case, Raziuddin Nazir, who was accused in 2008 serial blast case, demanded discharge on the grounds that he was acquitted by a Karnataka court in a case based on same conspiracy. There was no evidence against him with regard to the charges of criminal conspiracy, waging war against the nation, etc. His counsel argued that after his acquittal in Karnataka, trying Raziuddin again for the same offence would amount to double jeopardy. The High Court rejected the application on the grounds that Karnataka police investigation was not proper, as seen from the Hubli Court's 600-page judgment. It is very important to note that in this case, 780 witnesses were examined, and none of them turned hostile.